Hello, everyone. This is John Lamb and Roger Roots. We're out here in Bozeman, Montana. We've got some bombshell breaking news and the Bundy
Bombshell legal news in the Bundy
in
cases.
the Bundy case. It just was the Supreme Court just issued a ruling today. Roger's here to tell us a lot about this. What he's read over it. It's still just breaking. We just found out about it, and so Roger, tell us a little bit about this. The Supreme Court just ruled.
There's several legal developments that I wanted to update a little bit, but the big bombshell news is the U.S. Supreme Court earlier today in a case called United States versus Davis. The U.S. Supreme Court split decision ruled that those 924C counts, 18 U.S. Code Section 924C, which is using a firearm in a crime of violence counts, which has been on the books since the 1968 Gun Control Act. U.S. Supreme Court struck it down as vague, and it's unconstitutional. And remember, those were the counts that were at issue in the Bundy prosecutions, especially in the Nevada case. And those statutes carried huge sentencing implications. And Mr. Greg Burleson, one of the Bundy defendants in the first trial in Nevada, was sentenced to 68 years in federal prison Section 924C counts using a firearm in a crime of violence. And those have been struck down today by the U.S. Supreme Court as vague and unconstitutional.
Greg Burleson is sitting in prison. He's serving a 68-year sentence, and he is waiting on a new trial. This could be big news for him. It could overthrow that whole case, couldn't it? It may possibly get him thrown out.
I wouldn't say, the implications are certainly he's going to be resentenced. He's going to have to be. Now, I also wanted to discuss some of these other tangential cases, really all the Bundy prosecution cases. There's a lot of developments in the Ninth Circuit Court of Appeals. Mr. Burleson, Greg Burleson, I don't believe is in the Ninth Circuit yet. He is still in the U.S. District Court in Las Vegas, Nevada, in front of Navarro still, and I believe his attorney has a very, very exhaustive motion even filed his appeal. As far as I know, I haven't looked recently, but I believe he's still at the trial court with a motion for retrial. Now, he was sentenced to those, the 68 years in prison was from the 924C counts. Those were basically since the 1968 Gun Control Act. The federal law has added all these horrible sentencing implications for anyone convicted of using a firearm in any crime of violence. Now, that phrase crime of violence is a little bit vague. I mean, we all know it when we see it, but there are many federal statutes, and several of them were involved in these Bundy cases, even in Oregon, where count one, might have been count two in Oregon, which was using a firearm in a crime of violence in violation of 924C, and that crime of violence in that indictment in Oregon was conspiracy to impede federal officers. Now, the judge in Oregon, Judge Ann Brown, ruled that crime of violence was not a crime of violence as intended by 924C. So she struck down, even before those trials began in Oregon, struck down count two as they struck that out of the indictment. And by the way, that same count two, using a firearm in a crime of violence, that crime of violence being conspiracy to impede federal officers, was also count two in Nevada, and Judge Navarro also removed that even before those trials began. So that gives you an idea of how difficult it is for these judges to determine what is and what is not a crime of violence. Now, the Nevada indictment was horribly, you talk about one of the most brutal, barbaric indictments ever written. It also had three other 924C counts. All those defendants in Nevada, the Bundys and Eric Parker, Scott Drexler, all those guys, they were all facing those 924C counts, using a firearm in a crime of violence, that crime of violence being threatening federal officers. Then there was another count, 924C, saying that the crime of violence was assaulting federal officers. Then there was another one saying using a firearm in a crime of violence for, I believe, extortion. So they had four 924C counts. Now, what's really evil about those counts is the sentencing implication, because if you're convicted of one of those, using a firearm in a crime of violence, just by possessing it, it was mandatory minimum 5 years in prison above all other sentences in the case. For brandishing, it was mandatory minimum 7 years in prison, in addition, consecutive to all other sentences in the case. Now, by the way, consecutive sentences are not the norm in criminal cases. The norm is concurrent sentencing. If you normally, when someone is convicted of, let's say, 11 counts, 12 counts of different offenses from an incident, the judge will sentence the person to concurrent sentences. So the person will serve all those sentences at one time. It is unusual. It is an exception to sentencing law where a judge imposes consecutive sentences. But those 924C counts were written by the U.S. Congress in 1968 so that it's a mandatory consecutive sentence, and for anyone convicted of more than one of those 924C counts, let's say if you're convicted of 2 or 3 or 4 of those, the sentences go up. It's not a mandatory minimum 5 years. Count 2, if you're convicted of the second one, it's 25 years to life. So all those guys in Nevada were facing 25 years to life if convicted of 2 or more of the 924C counts. And Burleson was convicted of 3 of those counts, and he was given 68 years. I believe the U.S. Supreme Court decision today is going to require that he at least, even if he doesn't get a new trial, and even if his case was even upheld and sustained as it is right now, the U.S. Supreme Court has struck down the 924C counts as unconstitutionally vague today in a split decision. Gorsuch is the libertarian on the Supreme Court. That was Trump's first nominee. Gorsuch is the man. He joined the so-called liberals on the Supreme Court, Sotomayor, Kagan, etc., and they outvoted the conservatives on the court. Go Gorsuch. They struck him down as unconstitutionally vague, and now Mr. Burleson and many other people across the country, by the way, who are facing extremely long prison sentences, will need to be resentenced.
If everybody doesn't remember the case there in Nevada, there was 19 defendants all total. There was only 2 defendants that actually were found guilty by a jury. That's it. Out of 19 at trial, only 2, and that was Greg Burleson and Todd Engel. And Todd Engel got 68 years.
No, Burleson got 68 years.
Todd Engel got 14 years.
14 years. Now, I'm involved in the Todd Engel case a little bit. Todd Engel's case is before the Ninth Circuit. The jury convicted him of 2 counts out of 16. One was obstruction of justice, and 1 count of interstate travel in aid of extortion, whatever that means. When I was in the courtroom when he was convicted, and I thought to myself, well, that was count 16, the last count. Usually the indictments are written so the worst, the most extreme, the hardest count, the count that is, let's say, the big count in the case is usually count 1. And then count 2 is not as severe, count 3 not as severe. I was in the courtroom. Count 16, which I hadn't really focused on when I was doing all my legal research in the case, was interstate travel in aid of extortion. I didn't think it was that, because I hadn't really looked at the sentencing implications of that, but it was up to 20 years in federal prison, and the sentencing implications of count 16 for Todd Engel were as extreme as if he'd been convicted of extortion itself, up to 20 years in federal prison. So he ended up getting 14 years, and he's up on appeal. Warren Markowitz of Las Vegas, Nevada is his attorney in the Ninth Circuit. I have filed a proposed amicus brief, a friend of the court brief, on behalf of 2 organizations out of Idaho, the Idaho Political Prisoner Foundation and the Real 3 Percenters of Idaho. And I'd like to just shout out to Eric and Andrea Parker and what's the other guy for Idaho Political Prisoners?
Anthony
Depew. I'd like to thank all you guys. We have filed a proposed friend of the court brief in support of Todd's case. Todd actually needs to be released. He was convicted in the same case where the judge later found, Judge Navarro later found, that there had been massive Brady violations by the prosecution. In other words, the prosecution had been found 3 trials later in a trial that involved Cliven Bundy, Ammon Bundy, Ryan Bundy, and Ryan Payne, that the government was withholding exculpatory evidence tending to show innocence, and had dismissed the 3rd trial down there while knowing that Todd Engel 2 trials before had been convicted in a case, the same exact case that had the same exact withholding of evidence issues. And so Todd Engel really needs to be released. He was also had many other of his rights violated, including his right to represent himself fully, to meet with lawyers in the prison fully, and many other of his rights were violated.
We got some other information too on some other cases.
There are other cases. Yes. The Ninth Circuit also right now is considering the appeal of the second Bundy case in Oregon. Now, that case, of course, involved the occupation of the Malheur Wildlife Refuge in Oregon, Eastern Oregon. We know that trial 1 ended with acquittals, full acquittals, not guilty verdicts. Ryan Bundy, Ammon Bundy, that whole group was acquitted, fully acquitted in trial 1, and that was October 2016. Trial 2 involved 4 different defendants: Dwayne Emmer, Jason Patrick, Jake Ryan of Montana, and Daryl Thorne. And they went to trial in February 2017, and they were all convicted of at least 1 felony count. That case, even it's been that appeal has gone on and on and on. I should say the current developments are that the government has just filed a motion which has been granted for an extension of time to file its reply brief. The 4 convicted defendants, Thorne, Ryan, Patrick, and Dwayne Emmer, they've all served their sentence and are out right now. They're on supervised release, generally speaking. What's interesting, because I've been following that case, and I'm also filing an amicus brief in that case on behalf of the same 2 amicus organizations, the Idaho Political Prisoner Foundation and the Real 3%ers of Idaho. So I've been watching that appeal, and there's been lots of extensions of time. The appeal has been pending for about 2 years. And remember, there's 4 defendants, so in a case where there's 4 defendants combined in the same appeal, the courts give more leeway with regard to the number of pages and such. That the appeal brief that was filed by the 4 defendants / appellants, they are now appellants in the Ninth Circuit, is 150 pages long, and it has many different issues, many different arguments by their lawyers that their convictions were unconstitutional in one way or another. What's interesting now, a good appellate lawyer always puts his first issue first. So even if you have, let's say, five big issues on your appeal, you want to put the big issue first, the one that's going to win. And I was watching that, wondering what issue was going to be the big issue in that appeal, the Oregon Bundy Trial 2 appeal in the Ninth Circuit. And when they came out with that 150-page brief, and that was just about a month ago or 2, their big issue was one that I actually think has a great chance of success. And that is the fact that Judge Ann Brown, the trial judge in February 2017, had culled the prospective juror pool. She had taken 800, there were 800 people in the prospective jury pool in that trial. And before the trial even began, Judge Ann Brown had essentially culled 400 and just basically stripped them from the jury pool before the trial even began. So there was 800 names of potential jurors, and Judge Ann Brown had taken 400, half of them, and just stripped them out. And her reasoning was, I'm sure that some were probably good reasons for getting rid of some of them. Disabilities, too old, too young, whatever. They didn't qualify legally. But there were many, apparently, that Judge Ann Brown, just in her own chambers, without any discussion with lawyers from either side, just stripped from the jury pool. And so when the jury trial began with jury selection on the first day, it was a list of only 400 names, not 800 names. Now, what's interesting is the lawyers had no opportunity to object in that trial. And I'll just say that is a very, very, very strong issue for appeal. And I'll actually go on record right now saying that it's probably, I don't know, I'll go 60-40 that Jason Patrick, Daryl Thorne, Jake Ryan, and Dwayne Emmer are going to have their convictions overturned on that ground. I'll go 60-40. Who knows? I came in and I wrote I was working with FIJA at one time, Fully Informed Jury Association, with a prospective brief. We had a big issue that we thought was a huge constitutional violation, which is that in that trial, in addition to the other problems, Judge Ann Brown had added or allowed the government to add misdemeanor counts that were going to be tried by the judge, not the jury. In other words, during that jury trial, when these 4 defendants were facing felony charges, Judge Ann Brown was also trying the defendants at the same time for misdemeanor charges in her mind. So she's trying them in her mind for misdemeanors while the jury is trying them for felonies. And there's a long, it's called the petty offense exception, and it is unconstitutional. It's been upheld by the Supreme Court in some split decisions, but it's unconstitutional. In 2 different places, the U.S. Constitution requires that all crimes be tried by jury. That's in Article 3 of the Constitution, and again in the 6th Amendment, which actually says that all accused shall have the right to a fair, speedy, and public trial by jury. So that's right in the Constitution 2 times. Article 3 actually says the trial of all crimes shall be by jury. That's Article 3 of the Constitution. But over time, what has happened is courts have allowed petty cases to be tried by the judge, even though a defendant might demand a jury. And so in that case, remember, it was bombshell verdict in October 2016 when the jury came back with the acquittals in trial 1. And so for trial 2, the government was still trying to figure out how it could ensure convictions for those 4 gentlemen. And they convinced the judge to allow these misdemeanor counts to be added to the trial. And then Judge Ann Brown would be trying the defendants in her mind at the same time the jury was trying them. And FIJA, I was working on some research on this. At one time, there was discussion of Fully Informed Jury Association supporting an amicus brief. Later on, FIJA thought they should have more organizations added, and there was a scramble. And I had done all that research. I was in touch with the Parkers and with Depew, and they agreed to support the amicus brief in that case. So I'm actually working on 2 Ninth Circuit friend of the court briefs, and we're arguing that the hybrid trial with the judge and the jury at the same time is totally unconstitutional. By the way, it's unprecedented. It needs to be struck down on that grounds. So those misdemeanor convictions need to be struck down. But I'll go 60-40 that the other issue, which I'm not involved in, the issue of the judge culling the jury list, the jury pool list in advance of the trial without consulting the parties, I'll go 60-40 that's going to be overturned. Of course, the big Bundy case, and that's the case Cliven Bundy et al., and that's the United States versus Cliven, Ryan Bundy, Ammon Bundy, and Ryan Payne, is also on appeal. The government has appealed the dismissal of that case. That's also on appeal in the Ninth Circuit. And, it's probably going to be another year or who knows how long before that's decided. Right now, I believe Ryan Payne's lawyers, the Federal Public Defender's Office of Nevada, has filed a motion for continuance to file their response brief, so it's still in limbo a little bit. But we do know the identities of at least 2 of the judges on the Ninth Circuit who are going to be considering that case. And remember, it's vitally important. Who the judge is in your case is vitally important. It shouldn't be as important as it is, unfortunately. But frankly, a lot depends on who the judges are. And we do know 2 of the names. There'll be a 3-judge panel. All these cases have a 3-judge panel. We know that Judge Fletcher and Judge Watford are the 2 Ninth Circuit judges. Recently, they also tack on a U.S. District Court judge, a trial judge. They bring them up and they sort of schmooze. These judges like to get together and schmooze, and they're all very friendly with each other. And frequently, they'll invite a district court judge to be the 3rd judge. But Fletcher, who was a Bill Clinton appointee, I've argued in front of him myself. Very intelligent judge, very intellectual. And the other one is Watford. Now, Watford is an African-American judge who was appointed by Obama recently. He's young. At one time, there was talk of him being on the Supreme Court. Before Obama left the presidency, he actually had a short list. Ultimately, he chose a guy out of, I think, the D.C. Circuit named Merrick Garland. And Merrick Garland didn't get on the Supreme Court because, well, Mitch McConnell and the Senate Republicans decided not to even consider it because Obama was a short-timer. Anyways, Watford was on the short list to be on the Supreme Court. Again, he's very young. I believe he's fairly liberal, African-American, and he's also on the appellate panel for the Big Bundy case. Let's see, what's the other? The big bombshell news, of course, is the U.S. Supreme Court decision today in the Davis case, which will require that Burleson's 68-year sentence be revisited, at the least.
Was you going to tell us a little bit about your case with Ryan?
Oh, that's right. I'm also involved representing Ryan Payne and Victoria Sharp in a lawsuit case in the U.S. District of Oregon. That case has been we've faced a lot of hurdles in that case. The trial judge has dismissed the Joseph Astorita of the FBI hostage rescue team, totally dismissed him from the lawsuit on grounds that we failed to properly serve him. Now, his attorney was served more than once, and there's actually case law in the Ninth Circuit and elsewhere that says an attorney that deals with a particular set of legal facts can be considered to be obliged to accept service for the same defendant in a similar case involving the same issues. So we served the attorney for Astorita with process servers and certified mail and by email. Maybe we didn't get him by process server, but in any case, we have email exchanges where the attorney was actually served and emailed the lawsuit. But the judge says that we had to physically serve Astorita himself. Now, Astorita works for the FBI hostage rescue team, and he's, which is a covert agency of the FBI, which operates in secret and actually requires that every other agency they work for has to turn off their body cams. That's how afraid they are to show themselves and identify themselves. So this is a covert agency, almost impossible to serve. But anyway, Astorita has been dismissed. Right now, the only other named defendant is Bretzing, who had been the regional director of the FBI at that time, Greg Bretzing. The federal government is moving to dismiss him from the lawsuit, and that will leave nothing but a bunch of John Does. And so we faced a lot of hurdles in that lawsuit. And after more than a year, we still haven't really even got discovery. There's a lot of case law that says you can use discovery preliminarily to reveal the identities of the John Doe defendants. In this case, we haven't even been able to get to discovery because we've been involved in these motions to dismiss and whatnot on failure to serve grounds. So anyway, we're still working on that case.
And then their names are still sealed. All those John Does.
All the John Does are still sealed, unknown. Every effort to have them, their names revealed so that we can amend the complaint and name them as defendants in the case. All of our efforts thus far have been turned away.
I think that's about all of our updates for the day, isn't it?
It is. Now, we should also say that our friend John Lamb here is a father for the 12th time. Now, this is major news in itself. Poor Rebecca. Rebecca, his long-suffering wife, she's given it all. You could not find a more hardcore wife than Rebecca, and she just gave birth to her 12th child.
Well, last Sunday, June 16th, a little boy. So
amazing news for John Lamb, and congratulations. And Rebecca, we hope you're watching this because you should get an award, Mother of the Century.
We do also have I just got a book today, and Jeanette Finicum, LaVoy Finicum's daughter. I just got this book. I haven't got to read it yet, but if everybody hasn't bought this book yet, I'm going to do a live stream here soon. I'm going to go through this book and try to read up on it. And but Liberty Rising, and it's an awesome book by LaVoy Finicum's daughter, and I'm looking forward to reading it. I just got it in the mail today, so but I'll give you some more updates later on that, and we'll also have some more updates just soon here on this bombshell news of this case we just found out about today. Supreme Court versus Davis.
It's called U.S. v. Davis, and it struck down the 18 U.S. Code 924C as unconstitutionally vague. And our man, Neil Gorsuch, who is really a libertarian, he's the only libertarian on the court, really, joined the so-called liberals in that case. Great decision today. And so my hat is off to Gorsuch. By the way, it was Aaron Davis of Rudy Davis and Aaron Davis fame from Texas, who tipped me off today. So shout out to Aaron Davis about that great decision.
We still got lots of political prisoners in prison across this nation. We've got Schaefer Cox, Joshua Martinez. He's sitting in jail in Las Vegas. Schaefer Cox is in Terre Haute, Indiana. There's many other names up there. Jeff Winehouse is in Missouri. So keep all them guys in your prayers. If you guys can get addresses, send them letters. Tell them you're thinking about them, and encourage them in this fight for freedom. Have a good day. God bless.